Martial law is intended to be for informational purposes only. This information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of those differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Maybe someone like Marshall Chriswell, who's across the microphone from me now. Good morning.
Good morning.
Hey, wanted to talk with you today about a bill that has passed in the Senate. I don't know, has Governor Wolf signed it yet?
It has. It was, if we're talking about SB 844, that was signed by Governor Wolf on May 4th.
Okay. It has been billed, and you point this out as well, as the grandparents' rights law in child custody cases. And Senator White told us here in Indiana in the morning, in particular, when he wrote it, he was thinking of homes that are affected by the opioid epidemic, and families get torn apart in those situations, and oftentimes you have a boyfriend or a girlfriend who ends up with custody of children while grandparents are frozen out of that process. This it's a little bit more complicated, a little deeper than that, but let's talk about some of the effects that you anticipate as an attorney from that law.
Sure, yeah. I think that depending on how this law is interpreted by the courts, by judges in common pleas courts, and eventually, in appeals cases in the Superior Court and beyond, this could really have a profound effect on situations where homes have been affected by drug abuse and other situations as well. But it's really tailored and like you said, the intent was to address the opioid epidemic. The law provides that there is an expansion of grandparents' rights, particularly for partial physical custody, so not primary custody, but for partial physical custody, an expansion of grandparents' rights there, and that's specific to grandparents. But there's a larger part of the law, the biggest kind of the centerpiece of the law, is that third parties, so as people that aren't parents, aren't biological parents of a child, and this includes grandparents and others as well, if that person comes into court and can demonstrate by clear and convincing evidence that they have a continuing relationship with the child, a bond, and the law says a sustained, substantial, and sincere interest in the welfare of the child, and if they have assumed or are willing to assume responsibility for the child, and if it's a situation where the parents themselves don't have care or control of this child because they are, either in the throes of addiction or just absentee parents, then those third parties have standing to seek primary custody of the child or children, and that's a big change in the law. Yeah.
You used a word there, and the law itself contains the phrase legal standing. That's a key part of this. It puts those people in the courtroom, doesn't it, where before they did not have legal standing?
It does. The courthouse doors were closed to most third parties before this, unless they could show that there were specific rules for grandparents. Okay, so there have always been those, but they were more narrow than this is. But other third parties had to show that they were standing what's called in loco parentis to the child, meaning, and it's a funny legal term for acting as a parent. So if you were a step-parent that has been a part of the child's life for a significant amount of time, you acted as a parent to that child. You fed them, clothed them, participated in all their activities, formed a bond with them. Then the court could determine, okay, you stand en loco parentis to this child, and you have the right to proceed for custody. Here, this law fills in a big gap. A lot of times in situations, where parents are addicted, you have a child that is being cared for by other family members, not necessarily living with any one of them full time, and not necessarily having a parent-child relationship with them, but you have other family members that that have that really care about this child and have a bond with the child, even though they're not acting as a parent day to day. And the intent of this law is to give those folks standing, to open the courthouse doors to those folks to come in and say, okay, at least let me in the courtroom and make my argument at a custody trial as to why I should have custody of this child and not somebody else.
Mm-hmm. Now, for the family of the parents of the child, himself or herself, talk, if you would, a little bit about if they have designated somebody who happens to be outside their family to be the caretaker should something happen to them.
Mm-hmm. Sure. And that's a prudent thing to do. I've had that situation where you have a parent who knows that they're not in a good place in their life. And I think that's what you're talking about.
Yeah.
You have a parent that is cognizant enough of their deficits, whether it be an addiction or a financial struggle or just sometimes a parent is just too young. You have a teenage, a single mother who's a teenager. There can be all sorts of reasons why a parent might realize, oh, I need a backup person, and you can do that voluntarily. The other biological parent is always going to have rights as well. But whether those two come together and agree, or there are other situations, but you can appoint someone. Pennsylvania law provides for a standby guardianship document that you can sign. That's a legal document that says, if I'm not available to care for my child, this is who I want to do it. And that document can be used for purposes of education, healthcare, signing for consents for medical procedures, all sorts of things. So it gives you custody rights.
Okay. With the new law, I would assume that agreement that we were just talking about would stand higher in the court's eyes than even the new law.
Well,
would not be a determining factor, perhaps, but
it wouldn't. It would be it would show the biological parent's intent, and that's always important, an important thing for the court to consider. Mm-hmm. But if it looks like the biological parent didn't make the right decision, or that the person they've appointed is not the right person or is not available. The bottom line is the guiding principle whenever you're talking about child custody in Pennsylvania is what is in the best interests of the child.
Okay. Now, people sitting at home now listening this morning, knowing that this is now Pennsylvania law, are there steps that they should be taking now in order to at least get the background information so that if the situation comes up, maybe they can see something happening within their family where it could come up? That they get working on now what they're going to need to be doing in the future. I'm sure they hope that that it doesn't come up, but if it does, that they're ready.
Well, I think that there are situations like this all over the Commonwealth. I mean, all over the country, but I think there are situations everywhere where you have parents who are affected by drugs, and you have other family members or other third parties that are caring for children that would probably fall under the ambit of this statute. The statute becomes effective. The law becomes effective July 4th, I believe, because it was signed May 4th, and it was to be effective in 60 days. So on or about July 4th, this is going to become effective. And I think that there are situations like this all over, and you're going to see lots of these kinds of cases being filed. Yeah. And like I said, it's just going to be really interesting to see how the courts interpret it, because whenever you're drafting and I just read you, what I read is the language of the statute, word for word. And so, when you draft a statute, you can only put so much in there, so the courts have to fill in the gaps. And it's going to be interesting to see how they interpret that language, and whether it's a very broad interpretation, which is going to give lots and lots of these third-party caregivers rights to proceed in custody cases, or if they'll interpret it a little more narrowly.
Have you heard from parents or grandparents in this situation already? Do you anticipate that you're going to be? And what are the things they should be doing right now?
I don't think that a lot of people know about this. I know that it's been reported, but I don't know that it's really become common knowledge yet that this law and it's been reported, but maybe people don't realize the effect it's going to have. But I expect that once it becomes effective and people start hearing more about it, that attorneys are going to be getting lots of phone calls. Hey, this is my situation. I have a somebody says, I have a 3-year-old nephew. Mom and dad are both addicted to heroin. I take care of them, for a couple months or a couple weeks out of every month, more if they need me to. Do I have a right to seek custody of this child? Just those kinds of calls, and I think there are going to be a lot of them.
Yeah, I'm sure there are grandparents right now, or aunts and uncles who see one of their child's offspring in the care of a girlfriend or a boyfriend that's not even a blood relative right now, that feel that they're frozen out of the whole situation, that maybe they're beginning to awaken to this possibility as well.
Yeah, that's absolutely right. And that boyfriend or girlfriend, if the parents are having issues with substance abuse, a lot of times that the whole household's affected. Maybe the boyfriend or girlfriend is as well. So this gives those other relatives and third parties hopefully the right to come in and say, all right, let's have a custody trial and let me be one of those options for custody.
Now, the context in which we've been discussing this today has to do with opioid addiction, which is one of the stated goals of Senator White when he introduced the bill.
Right.
Are there other situations to which this would apply other than addiction situations?
It is not. The bill, although it was intended to address the opioid epidemic, it does not mention opioids or drug abuse, substance abuse at all.
So it's not circumstantial.
It is not at all. It is broadly written that any time biological parents do not have care or control of the child, and you have third parties who can show by clear and convincing evidence that they're involved in the child's life and that they want to take custody, they can come in and have standing. So it's going to address a broad range of situations.
Looks like a busy time coming for attorneys such as yourself.
It is, but hopefully, I'm really hopeful because particularly with the drugs, and it is all situations, but particularly with the drug situation, this is what we need is legislators stepping up and saying, okay, what do we need to do? How do we need to modify our current laws across the board? It's not just child custody situations. There's so many facets of life and therefore the law that it touches. So this is what we need is people stepping up and saying, okay, what do we need to do to make changes?
All right. Very good. And if someone wants to get in touch with you about this or any other legal situation, what need they to do?
Give me a call at 724-465-5826. Stop by our office in the Atrium Building, downtown Indiana, or go online to westernpalawyer.com.
Very good. Thank you, sir.
Thanks, Todd.
It is Indiana in the Morning, presented by First Commonwealth Bank.